Listen, I want you to picture the scene. Tuesday morning, 10:47 a.m. The lobby of a regional bank somewhere in suburban America. Dead industrial gray-blue carpet. Fake ficus tree in the corner. Bowl of stale peppermints nobody has touched since the Bush administration. And there, standing at the new accounts desk, is Margaret. She is 73 years old, wearing a cardigan because the AC in these places is always set to morgue. She has a manila folder with her driver's license, her social security card, and her son's information. Margaret is here on this perfectly ordinary Tuesday to commit financial suicide. She doesn't know that. Nobody told her. Her son David didn't tell her because his accountant said it was a smart move. Her financial advisor didn't tell her because he sells annuities, not legal protection. And the 26-year-old branch associate sitting across from her, Tyler, cheap polyester tie, corporate smile learned in onboarding. Tyler is absolutely not going to tell her. Tyler is going to slide a signature card across the desk, point at 3 lines and say, just sign here, here, and initial here. Tyler is going to upgrade her accounts to a joint tenancy with right of survivorship, JTWROS. And Tyler is going to congratulate her on her smart estate planning. Tyler is participating in a crime. Tyler doesn't know it's a crime. Tyler is just following the operations manual. What just happened in those 45 seconds is one of the most catastrophic, most legally devastating acts a senior in this country can commit. And it happens several thousand times a day in branches from Sarasota to Spokane. Before we get started, I'd really appreciate it if you could subscribe and hit the like button. Unfortunately, that's just how algorithms works, and I have to ask for this kind of support. It genuinely helps me keep making more content and releasing more videos like this. Thanks a lot for understanding. Alright, let's continue. Because Margaret didn't add her son to her account. That is not what happened. The bank doesn't see it that way. The court doesn't see it that way. The IRS doesn't see it that way. What Margaret did, in the cold, mechanical reality of property law in 2026, is she gave David a 100% ownership interest in every dollar in that account. Not 50%. Not joint with you, Mom. 100%. He owns it. You own it. You both own all of it simultaneously. Either one of you can walk in tomorrow and clean it out without the other one knowing. That is the legal definition of JTWROS. And here is the part that should make you absolutely furious. David didn't just get the keys. Every creditor David will ever have for the rest of his natural life also got the keys. Every plaintiff's attorney who ever sues David got the keys. The IRS, when it audits David in 2028, because of that side hustle he didn't report, got the keys. His wife Jessica, who right now is perfectly lovely and brings a casserole at Thanksgiving, when she files divorce papers in 2027, she gets the keys. The driver David hits next October when he rolls a stop sign and the policy limit is exceeded, that driver's lawyer gets the keys. Margaret thought she avoided probate. Margaret thought she was being a good mother. Margaret thought she was making it easy for David to pay her water bill if she landed in the hospital. Margaret didn't avoid probate. Margaret volunteered for her own son's bankruptcy. She enrolled herself, at 73, on Social Security, with a paid-off house and a $100,000 nest egg she scraped together over 50 years as a school nurse. As a co-defendant in every legal disaster that will ever happen to David for the rest of his life. This is not hypothetical. This is the day-in, day-out, courthouse-to-courthouse reality of how creditor law works in this country. And the entire banking industry knows it. They've known it for 40 years. And they will still upgrade you to a joint account with a smile in 90 seconds, because the alternative, the legally correct alternative that actually protects you, requires estate planning they don't sell. This is not official legal advice. It's a survival guide for an unguarded vault. Consult a fiduciary estate planning attorney. But don't tell me the IRS, in its twinkling benevolence, is looking out for the retired school nurse in Clark County. They wrote the rules. And the rules are the crime scene. Here is the trap the teller didn't mention. When you set up a JTWROS account, the bank does not maintain a ledger that says 80% belongs to Margaret, 20% belongs to David. The bank does not care who deposited the money. It does not care that David has never put a single penny in. It does not care that 100% of those funds came from Margaret's late husband's life insurance settlement. The bank's ledger says one thing. This account is owned by Margaret or David. That word "or" is the entire legal universe of this story. It means David, on his worst day, can walk in and withdraw every dollar and hand it to whoever he wants. The bank has zero legal obligation to call you, notify you, or leave a note. He's a co-owner. That's what you signed up for. The doctrine of joint tenancy goes back to English common law and was designed for married couples and business partners who fully intended to share assets equally. It was never designed as a substitute for estate planning between a parent and an adult child. But starting in the 1970s and 80s, branch banking started marketing JTWROS accounts to seniors as the easy answer. Just add your kids. Avoid probate. It's free. Hundreds of billions of dollars of senior wealth in this country are currently sitting in joint accounts where the senior thinks they own the money and the law disagrees. The moment David's name hits that signature card, three things happen simultaneously in the legal background, invisible to Margaret as she drives home feeling good about herself. First, David may have received what the IRS characterizes as a present interest gift. Depending on account use, this can trigger gift tax reporting requirements nobody in that branch mentioned. The 2026 annual gift tax exclusion is $19,000 per recipient. If David's interest exceeds that, someone is supposed to file IRS Form 709. Nobody is filing Form 709. There is now a quiet ticking compliance problem buried in your account that no human being is even aware of. Second, David's creditors, present and future, can now legally attach the account. Not theoretically, actually. In every state, a judgment creditor of David's can serve a writ of garnishment on the bank. The bank sees David as co-owner, freezes all funds, the entire balance. You can then go to court and try to prove the money was originally yours. In some states, you might recover some of it. In others, you'll fight for years and recover pennies. In the harshest jurisdictions, adding a joint owner is itself treated as evidence of intent to share ownership. You lose the whole thing. Third, if David ever files bankruptcy, applies for Medicaid, or goes through a contested divorce, that joint account is now part of his asset disclosure. He is required to list it. And the moment he does, his bankruptcy trustee, his ex-wife's divorce attorney, and the Medicaid caseworker are all looking at Margaret's $100,000 nest egg, asking the same question. How do we get our hands on this? Let's put numbers on this, because the numbers are where the horror really lives. Exposure 1. The at-fault car accident. David is 47, driving his daughter to soccer practice on a Saturday morning. He's rushing because he was on a work call. He rolls through a stop sign and T-bones a Toyota Camry driven by a 34-year-old physical therapist named Anna. Anna survives, severely injured. 2 herniated discs, traumatic brain injury. She can no longer practice her profession. The jury awards Anna $1.4 million. David's auto policy has a $250,000 limit. Insurance pays $250,000. There is now a $1.15 million judgment with no coverage behind it. Anna's lawyer runs an asset search, largely automated in 2026, results within hours of judgment entry. He finds the joint account. He files a writ of garnishment. The bank receives it Tuesday afternoon. By Wednesday morning, your $100,000 is frozen. Not David's $100,000. Yours. The money you saved after your husband died. The money for your hip replacement next year. Frozen. Inaccessible, pending judicial review. You hire a lawyer, $5,000 retainer. You spend $15,000 to $40,000 in legal fees over the next 18 months trying to recover your own money. Even if you win partially, a significant chunk is gone in fees. If you lose, the money is simply gone. Total cost of the convenience of having David able to pay your electric bill if you got the flu. $125,000. That electric bill, by the way, is $147 a month. You could have paid it for 70 years on the legal fees alone. Exposure 2. The divorce. David and Jessica have been married 14 years. Things have been crumbling for 4. In March 2027, Jessica files. It's contested. Nasty. Custody fight. Jessica's attorney pulls David's financial disclosures. He is required to list every account on which he is a signer or owner. He lists the joint account with Margaret. He has to. Lying on a financial affidavit in family court loses you the custody fight and gets you sanctioned. In a community property state, California, Texas, Arizona, Nevada, Washington, Idaho, New Mexico, Wisconsin, Louisiana, Jessica's attorney argues David's interest in the joint account is a marital asset subject to division. In cases where David has ever moved money in and out, where any commingling occurred, where the account was used for any household expense, the entire account can be found to be a marital asset. Margaret, 73 years old, is now sitting in a deposition being asked by Jessica's attorney about her own bank account. Being asked to produce 14 years of statements, being humiliated in a fluorescent-lit conference room in defense of her own life savings because she signed a card at a bank counter 8 years ago that nobody explained to her. In an equitable distribution state, the result is often equally bad. The existence of $100,000 in David's name tilts the entire settlement against him. So he ends up paying Jessica more, becomes financially crippled, and starts leaning on Margaret for help. Margaret's money walks out the door anyway, just through a different door. Exposure 3. The IRS tax levy. David runs a side consulting business and has been casual about reporting the income. Maybe very casual. The IRS audits 3 years of returns, finds $187,000 in unreported income, assesses $94,000 in back taxes, interest, and penalties. David enters a payment plan. David misses 3 payments. The IRS files a notice of federal tax levy. A federal tax levy attaches automatically, by statute, no court required, to all property and rights to property of the taxpayer wherever situated. The IRS issues the notice, serves it on the bank, and the bank within 21 days surrenders all funds. You, Margaret, receive no advance notice, no opportunity to be heard. You discover the loss when your debit card declines at the grocery store. You then file a wrongful levy claim, an administrative process in which you bear the burden of proving the funds were entirely yours. This takes 6 to 18 months. Your money sits with the United States Treasury, earning no interest while you wait. And the Medicaid trap inside the trap. Suppose David, finally realizing the disaster, tries to fix it. He takes his name off the account and transfers everything back to Margaret. Sounds responsible. It may be a Medicaid catastrophe. If within 5 years Margaret applies for long-term care Medicaid, the state will look at that transfer. Was it a transfer for less than fair market value? Some states say yes. In a state where nursing home care averages $9,500 a month, a $50,000 deemed transfer creates a penalty period of over 5 months. 5 months during which Margaret needs nursing home care and Medicaid will not pay. And she has no money left because she just spent her savings closing the account. The villain in this story doesn't appear in financial advice columns. It's the entire ecosystem of judgment enforcement, a brutally efficient industrial machine in 2026. Judgment creditors subscribe to commercial databases that aggregate banking relationships, real estate, employment records, vehicle registrations, business filings, and joint account information inferable from public records. They run automated searches. They generate target lists. They file garnishments in batches. The U.S. collection industry generates north of $20 billion in annual revenue. A non-trivial portion comes from finding and seizing joint accounts where elderly co-owners are sitting on funds exposed to a younger co-owner's debts. This is not a conspiracy. It is the predictable, profit-driven behavior of an industry that exists to find money and take it. The question is, why banking continues to push joint accounts on seniors as a convenience product? The answer? The bank doesn't bear the loss. You do. The bank charges fees whether the account is joint or single. The bank has zero financial incentive to warn you. Now, the path out. 7 steps. Step 1. Stop adding people to accounts. Effective immediately. Whatever the reason, whatever the probate avoidance justification, do not do it. The legally correct tools for the goals you actually have are different tools. Step 2. Audit every existing joint account. Write down every bank, brokerage, credit union, and money market account on which any name other than yours or your spouse's currently appears. Institution. Balance. Joint owner. This is your exposure map. This is the document you bring to an estate planning attorney. Step 3. And this is the most important concept in this entire video. Understand the difference between joint tenancy and a payable on death designation. A JTWROS account makes the joint owner a current owner today. They can withdraw funds today. Their creditors can attach today. Full ownership from the moment the card is signed. A POD designation, also called TOD on brokerage accounts, does something completely different. It says this account is owned 100% by Margaret while Margaret is alive. The moment Margaret dies, the account transfers automatically outside of probate to the named beneficiary. While Margaret is alive, the beneficiary has zero rights, zero access, zero ownership. Their name is not on the account. Their bankruptcy doesn't touch it. Their divorce doesn't touch it. Their tax levy doesn't touch it. POD and TOD designations accomplish the exact probate avoidance goal seniors are trying to achieve with joint accounts, without any of the creditor exposure. Ask your bank for a beneficiary designation form tomorrow. Every bank has one. The account stays in your name, under your Social Security number, under your complete control. When you die, David presents the death certificate and the funds transferred directly. No probate, no waiting. No court costs. Step 4. If your goal was having David able to pay bills during incapacity, the correct tool is a durable power of attorney for finances. A legal document in which you authorize David to act as your agent, not as a co-owner. He pays your bills, he deposits checks, he talks to the bank. The funds remain entirely yours. His creditors have zero claim. His divorce has zero claim. His tax issues have zero claim. Cost $200 to $700 for a competent estate planning attorney. Compare that to $125,000. The math is not subtle. Step 5. Save this video. Because when you walk into the bank to remove your child's name, Tyler or Tyler's supervisor is going to try to talk you out of it. But what about probate? Are you sure? Your son might be offended. Pull this video back up. This is your defense manual for the branch visit. Step 6. Have the conversation with your child. They are not the villain. They probably don't know this exposure exists either. Most adult children on parents' accounts have no idea that their car insurance limits, their marital status, and their tax compliance directly threaten their parents' retirement. Explain that you're removing them, not out of distrust, but out of legal protection. For both of you. The last thing a 47-year-old wants is to explain to a judge why his elderly mother is collateral damage in his legal problems. Removing the joint title protects everybody. It is not a rejection, it is a fortress. Step 7. If your situation is complex, substantial assets, multiple children, blended family, special needs, hire an actual estate planning attorney, not your cousin's divorce lawyer. An estate planning specialist. They will recommend POD designations, possibly a revocable living trust, a durable power of attorney, a healthcare directive, and a will. Total cost for a comprehensive plan in 2026, $1,800 to $6,500. One time. That is the price of a wall around your life savings that keeps every creditor in this country on the outside of it. Final warning. The legal architecture of joint ownership was not designed for 2026. Not for a country with 1.3 lawyers per 300 people. Not for an economy where a minor fender bender produces six-figure verdicts. Not for a tax system that can attach your accounts within 21 days of issuing a notice. Not for a divorce rate among Americans over 50 that has tripled in 3 decades. Not for long-term care that costs more per year than the median household's income. We are operating in 2026 with legal tools designed for 1926. The casualties are overwhelmingly seniors who did everything right. Who saved. Who paid their taxes. Who raised their children. Who walked into the bank on an ordinary Tuesday and signed a card that nobody told them would unravel everything. You cannot fix the system. The system likes itself exactly the way it is. But you can fix your own situation. This week. Before the next car accident, the next divorce, the next tax notice, the next something. The question is not whether the next something is coming. The question is whether your savings will be sitting where it can reach them, or whether you will have built the wall. Build the wall. Pull the names off the accounts. File the POD designations. Sign the power of attorney. Have the conversation with your kids. This week. Not after the holidays. This week. I'm the retirement insurgent. The vault is yours. Defend it. Drop a comment below with your state and situation. Did you add a child to your account for convenience? Did the branch officer suggest it? Did the funeral director after your spouse passed recommend putting one of the kids on there to avoid probate? I read every comment. I want to know how widespread this is, because my strong suspicion is the percentage is going to be devastating. Tell me your state. Tell me how long the account has been joint. Tell me roughly how much is exposed. Your answer might be the one that wakes another senior up. If this video told you something the bank never did, smash that like button. Share it with one parent or grandparent today. One conversation now can save somebody's entire retirement. Subscribe and flip on the notification bell. We are building the archive, documenting the legalized stripping of senior wealth in this country, account by account, jurisdiction by jurisdiction, statute by statute. The mainstream financial press is not going to do this work, so we will.